Welcome to Legatum. Today's legal insight is the continuation of yesterday's part 1, and today's legal insight will be in a layman's language wherein every person, irrespective of being a lawyer, a law student, or a layman, will understand today's lecture. So, we are talking about the case law of the Supreme Court of Rajnesh Vs Neha, wherein the party who's seeking maintenance has to file an affidavit of assets and liabilities. Now, what do you mean by this affidavit of assets and liabilities? The party who's seeking maintenance, pendent light, that is interim maintenance, has to file an affidavit of disclosure, thereby stating before the court on an affidavit in a sworn form what all assets or liabilities in his or her name, whether she is assessed to income tax, she is a taxpayer, the bank accounts for the last past 3 years, she has to submit all the bank accounts, or he has to submit, any party who's claiming the maintenance has to submit the bank accounts. And on an assets and liabilities, she is also has to disclose what the other spouse is earning, what are the liabilities, whether there are any mutual funds or not, whether any fixed deposits which she is receiving any amount. In short, the affidavit of assets and liabilities talks about the financial status of the person who is making the affidavit of assets and liabilities, and what are the needs of the person in respect of the assets and liabilities. After the affidavit of assets and liabilities have been filed by one of the parties, as I said in the last part, the respondent has to file the affidavit of assets and liabilities within 4 weeks. Within 4 weeks from the date when the assets and liabilities of the plaintiff or the petitioner is filed on record. In case if the respondent fails to file his or her affidavit of assets and liabilities, then the court may discard the evidence. I had talked about this, but in a layman's language, just to make everybody understand, I have stated this again. Now we are talking about a concept which normally people they are not aware of, which is called as interrogatories. Now, in Rajnesh versus Neha's judgment on page number 36, F, the clause F, I'll just read that. If there is any dispute with respect to the declaration made in the affidavit of disclosure, the aggrieved party may seek permission of the court to serve interrogatories and seek production of relevant documents from the opposite party under Order 11 of the CPC. Now, what is Order 11 of the Code of Civil Procedure? It talks about discovery by interrogatories. Interrogatories is nothing but, again, on an affidavit, the if the respondent or the petitioner who is not satisfied with the contents of the affidavit of assets and liabilities may make an application under Order 11 of the Code of Civil Procedure, thereby calling upon the other party to file an affidavit. And what do you mean by interrogatories? Interrogatories are nothing but question forms. There are certain questions in a format of a question. The party asks the other opposite party to answer these questions on an affidavit by way of interrogatories. This is called as interrogatories. And then after the filing of the interrogatories, the matter can proceed. And lastly, if everybody sees that enclosure, the format which is there, in the last section of that format, there is a declaration which each party who's making the affidavit of assets and liabilities have to give a declaration that they're fully aware of the consequences whatever they have stated in the affidavit of assets and liabilities, which is also called as the affidavit of disclosure. If there is any discrepancy of or any form, they'll be liable for criminal prosecution and they'll be liable to face a jail term. They are very much aware of it, and affidavit of assets and liabilities should not be taken so much lightly. Thank you.